Hi everyone, welcome to today's webinar. We'll be getting started in a couple of minutes. We just want the Zoom room to fill up a little bit more. You're all very welcome, and you can say hi, introduce yourselves in the chat if you would like to. We'll be getting going in a couple of minutes. Afternoon, everyone who's just joined us. Great to see you all coming into the Zoom space with us today. We're just going to wait for the Zoom room to fill up a bit more before we get going. You're all very welcome. You can introduce yourselves, say your union, your workplace, if you like, in the chat panel. Always good to hear what's happening at work. You can tell us a bit about your experience of this subject there as well. And I can already see lots of you saying all your different locations and your different unions, which is great. Okay, I will get going with a bit of webinar housekeeping. Thanks everyone for joining us today. I'm Anna from the TUC and I'm joined by Mark Allen from Thompsons Solicitors. I'll be getting him to introduce himself properly to you all shortly. But if you're new to webinars or if you're this isn't your first time, welcome or welcome back. If you want to follow along today with live captions, you can do so by clicking the show captions button at the bottom of the screen, and then you'll be able to follow along with those. We're of course recording today, so if you miss anything or you want to re-watch it, don't worry, you'll be able to do so because we'll send you the link to this webinar either later today or tomorrow morning, along with any resources that Mark talks about or that we think might be helpful to you. We've saved some time for questions for Mark after the main bit of the webinar. So if you've got any, please do post them in the Q&A section. Again, underneath the video screen in a speech bubble with a question mark in it. So before we get going on the questions I've written for Mark, just a little bit about the subject. We're going to be talking about work-related upper limb disorders, or WRULDs, as we commonly refer to them as. And I've got a list of questions to put to Mark about those. But first of all, before we kick off, Mark, can you tell us like a little bit about what you do at Thompsons and your background, please?
Sure, yeah, well, good afternoon, everyone. Thanks for joining us. As Anna's already so kindly introduced me, I'm Mark Allen from Thompsons. I have been dealing with work-related disease claims, always on the claimant side of the fence, thankfully. Never worked for the dark side, as I like to call them. For 33 years, I specialise in these sorts of cases. And hand-down vibration cases, which I'm also going to discuss in a little bit of detail today.
Sorry, no one could hear me then. Thanks for that. So my first question to you, what do we mean by work-related upper limb disorders or WRULDs? Can you tell us what that means and some examples, please?
Yeah, I mean, it's quite a large umbrella term, I would say, is work-related upper limb disorder, and it's really a whole range of sort of musculoskeletal conditions, effectively affecting the hand, wrist, arm, shoulder, and neck. So it's really any sort of condition that affects those sort of parts of the body. The sort of common ones, I would say, are carpal tunnel syndrome. And just for adding a little bit of confusion right at the start, um, carpal tunnel syndrome can be caused by vibration, but it can also be caused by repetitive actions, gripping, wrist flexion, poor posture, that sort of thing. So in the workplace, you've got to be really aware as to whether, of course, there may be vibration exposure, maybe, of course, combined with those sorts of activities as well. You've also got things like tendinitis, tenosynovitis, of which there are sort of several conditions or sub-conditions which fall within that. Epicondylitis, or what people may have heard as perhaps more commonly called tennis or golfer's elbow. And the only difference between tennis and golfers is which side of the elbow is affected, the outer or the inner. Rotator cuff injuries are also relatively common as well. But really, that's the sort of the sort of main gist of it. As I say, within like tendinitis, tenosynovitis, you get subconditions like de Quervain's tenosynovitis, for example.
Thanks, Mark. And just something I meant to mention before, we do have a presentation resource for you with lots of these conditions listed in, but we'll be able to send you a copy of along with the recording, and we will have it up on screen for some parts of today. But don't worry, you don't need to write everything down that Mark just said. Okay, so we've just heard what some of these upper limb disorders are, or vibration syndromes, but what are some of the causes of these?
Well, they can be caused or indeed pre-existing conditions, which maybe a constitutional condition, may be accelerated or aggravated by such things, such tasks as awkward posture is often a common one. If a worker is using sustained force, so that may include pushing, pulling, twisting, and certainly prolonged grip, and whether that might be a power grip, so effectively using the whole of the hand, all of the fingers, and usually the thumb, or a pinch grip, so usually using the first finger and the thumb. So those are the common causes really of upper limb disorders.
Thanks, Mark. Sort of a bit of an extra question. Do you notice, or is there evidence of particular sectors or particular industries where we see more of these than perhaps in others?
It's so wide ranging because it can affect everyone from the office worker, through keyboard use, for example, and indeed, people working in offices might not necessarily, you might think, expected to be dealing with heavy loads and carrying and that sort of thing, but that's often not the case. So you really get it from, your sort of office workers right down to the people that work on, factory floors, for example, and in factories where you might expect that the work potentially could be quite fast paced, could be quite repetitive, very target driven. You can imagine someone on a production line, for example, having to keep pace with the line and how repetitive and potentially awkward all that might be.
That's great, Mark. Thanks. So I wanted to ask you next about causation. Is this something we need to bring up some of your resources for? Or,
It's probably worthwhile, I think. Yeah,
yeah,
bringing up
okay.
the slides. I think. Yeah, I think
So
we
while these
can.
are being loaded up, could you just, before we go into the legal issues in detail, look, what are the sort of headline things that reps need to think about around causation?
Well, often upper limb disorders, work-related upper limb disorders, are multifactorial, I would say. So the thing is, okay, yes, we need to be concerned with what's going on at that moment in time. So if someone starts to suffer from symptoms of what they believe to be a work-related upper limb disorder, of course, we're going to look straight away as to what that individual is doing at the moment in time. But that's not really to forget about other tasks that that person may have been doing. So particularly if there's job rotation that's involved in that, of course, you've got to look at all the different tasks within the different rotated tasks. And of course, all the risk factors really that I've mentioned earlier. So, awkward posture, repetition, force, that sort of thing. You've got to look at all those issues really by way of course, causation. Of course, medics and certainly us as lawyers as well, of course, we'll have to look at whether there's been any pre-existing history, of course, for that individual. So are we truly talking about something that's been caused by the said work and the said processes, or maybe it's an underlying constitutional condition. And sometimes you do see that where someone's, had a pre-existing problem, let's say with the shoulder, and then there's a part of the work or the work's changed, and all of a sudden previous shoulder symptoms may have arisen again. So those are the sorts of things to be aware of, I think.
Thanks, Mark. So, shall we just move through the slides till we get to the
Mhm.
causation bit so that we know what we're referring to? So let's just jump forward a bit till we get to causation. Okay,
Here we go.
should we stop here? Right. So, my original question: what are some of the legal issues that reps need to think about around causation if they're supporting members in the workplace?
Well, I think certainly to document clearly, chronologically what has gone on. So, where any member obviously is presenting with difficulties, reporting those difficulties, of course, you would hope that the employer is recording all that and taking the necessary action. But I think certainly if the rep is keeping a record of discussions that have been ongoing, whether that's been, with a member, with anyone in management in the workplace. So documenting it, I think, is clearly quite important. What you, of course, would hope to see is if any person at work starts to suffer with what may well be an upper limb disorder, is that they're being referred to occupational health. If there's no occupational health, because it may well be it's a small workplace, for example, and they don't have that in place, then again, it's sort of common sense, really, I suppose. But really, the member ought to be, of course, referred really to their own GP where there's no occupational health.
Thank you. Is there anything else we should consider around causation? Because I'm aware that you've got quite a few resource slides on it. Should we, before we move on, should we talk a bit more about causation first?
Well, the sort of slides obviously cover some of the sort of points that we've already discussed. Within the slides, there's quite a bit of detail, certainly in relation to hand-arm vibration syndrome. So I'll say a few words on that. It's quite detailed, so I'm not going to sort of repeat all that's on the slides, or we'll
No,
never
but
get done within an hour, that's for sure.
we've not covered the HABs part of it specifically yet, so do feel free to tell us a bit more about those where you think it's going to be helpful.
Yeah, as I mentioned, carpal tunnel syndrome, which is a bit of a sort of unique condition, really, in that, as I mentioned earlier, it can be caused by vibration exposure. Certainly, if you accept what the Industrial Injuries Advisory Council say, and it is a prescribed disease, so accepted for IIDB. But also, it can be caused by, as I've mentioned previously, repetitive movements, forceful gripping, poor posture, sort of wrist flexion, that type of thing. So that sort of falls within the umbrella of halves, of course, where someone has been exposed to sufficient vibration. Now, the symptoms of sort of what's called sensory neural halves, so this is really the tingling, numbness, loss of sensation that people get with halves, is very, very similar to the symptoms that you can get with carpal tunnel syndrome. The easiest way to usually tell the difference between the two is either on someone undergoing what's called a nerve conduction test, which will basically see where the nerve entrapment is, and that should pick up whether it's at the carpal tunnel, which of course is in the wrist, or not. Um, uh, and as I say, it can be one of those difficult ones to sort of differentiate, quite frankly. Um, it is one of those weird and wonderful conditions. It can be really difficult to figure out what the potential cause is, but potentially you can be looking in some cases of someone that is not only exposed to vibration, but also, of course, they've got the other risk factors as well. So it may be caused by both. It is quite awkward. Um, on the vascular side of halves, that's a sort of different component to the condition. And that basically is the sort of whiteness of the fingers, which sort of develops at the fingertips and spreads down the fingers towards the palm of the hand as vibration exposure continues. Now, again, you have to be careful about this because the sort of vascular blanching, as it's been just described, fits within what's called Raynaud's phenomenon. And Raynaud's phenomenon can be a constitutional condition, or of course it can be secondary to vibration exposure. Now we call it hand-arm vibration syndrome. The medical profession will call it Raynaud's, and they have to differentiate between it being a constitutional blanching or Raynaud's phenomenon, or of course secondary to vibration. There are a number of things that you have to look at. So where you've got a vibration induced condition, so whether that's carpal tunnel syndrome or HAVS, the vascular sensory neural symptoms, they really start at the time of the exposure to vibration. So it's not one of these conditions where there's a latency period and you might expect the symptoms happening sometime after the vibration exposure may have ceased. So again, what you typically tend to find is the individual starts with the symptoms whilst they're exposed. They gradually get worse with further exposure, as you might expect. So if someone's presenting with these sorts of symptoms and the last exposure to vibration was years previously, then it's clearly just not going to be hand-arm vibration syndrome. As I say, the sort of blanching is quite well demarcated as well. So it does start at the fingertips spreading down, and it's sort of quite a sort of solid line where it ends. So a blotchiness or a patchiness in its appearance, again, is not really typical of HAVS. I think we probably need to move on to the next slide, I think. Yeah, I've sort of mentioned about the sort of latency and obviously about the different conditions. Again, with HAVS as well, you sort of typically expect the sort of symptoms to persist for at least 20 minutes. They're generally provoked by exposure to vibration and usually exposure to cold as well. So if someone of course, is exposed to cold temperatures. So, they go out of the warm house in the morning to, defrost the car or something. That will often provoke an attack of the symptoms. And that typically lasts longer than sort of 20 minutes or so. Again, if it's much more short-lived, query whether, of course, that is actually hand-arm vibration or not. And I think
Well, I've just following up the something's on the slide, Mark. You've said here that other things that might be an influence on causation are, a poor working environment in general, including, for example, temperature, lighting, poor work organization, job demands, workload, all those kinds of things that I think are the everyday concern of reps. Can you talk a little bit about how they influence these conditions and maybe what reps can do in those areas?
Yeah, well, I mean, clearly, early intervention, I think, is really important. Seeking medical advice and trying to implement change in the workplace, I think, are really, really important. So if it clearly becomes an issue that someone is becoming symptomatic, or maybe more than one person, maybe multiple people are being affected at work by the same thing, which of course then does suggest that commonality, and much more likely that of course whatever's going on at work is the actual cause of these problems. So I think early intervention is one. I think clearly getting the employer to ensure, if they've not already done so, that they've clearly looked at the workplace, they've looked at the ergonomics of it, what is going on, can manual tasks be avoided? These are the sorts of questions that employers should be asking. So where, they can either be eliminated completely or reduced, or at least, if the risks from those can be reduced. So can the frequency be reduced? Can the load, weight, all these things that are factors be reduced? Is job rotation, one way in looking at reducing the exposure? And I say that with one caveat as well, in that I do see on a frequent basis employers, and of course, when it comes to a claim, their insurers seeking to defend a claim on the basis of, oh, well, we have job rotation. There's four different tasks that this individual does, and they all rotate between them. But when you actually drill down to the different tasks that are being done, none of them are providing any sort of rest. They all have their own risk factors within them. So them say, well, we're moving people from one workstation to the next, and that's appropriate, and that minimises the risk. When often that's just not the case at all. So what risk assessments have been done? What are they suggesting? Have they seriously used the HSE's art assessment tool, which is probably the best thing out there, to assess basically the risks that are potentially presented. All those things, I think, are the important things to look at. And it's really difficult because, of course, the regulations say, well, yes, you've got to do a risk assessment, and they talk about it's a competent person that does the risk assessment. Well, there's no definition of what a competent person is. What sort of training, what sort of experience has the person who's doing the assessment got? Do they actually understand, the tasks that are being assessed? Lots of different questions, and I'm sure some of the reps out there will already no doubt be going, oh yeah, I can talk about some difficulties I've come across with individuals who have been in the job 2 minutes, they don't understand what's going on, they've looked at one part of the job, and that's what the risk assessment's based on, and it seems that the risk assessment clearly is not a competent risk assessment on that basis. So those are certainly things that can be looked at. Often things, around working practices, again, can be really helpful. So, are there regular rest breaks? Is that something that the workers are able to actually take? Because it's all well and good saying you must take a 10-minute break every hour. If they say, well, I can't do that because we're going to keep up with the production line, or whatever the reason is. There may be appropriate stretching exercises that ought to be carried out, certainly before starting work, and maybe at regular intervals throughout it as well. Again, ensuring proper posture, because quite frankly, the best posture normally is stood up straight, quite honestly, but we can't all stand up straight to do our job. So, are we having to lean, bend, twist, that sort of thing? So posture is clearly, obviously, quite important as well. And training and education, because often people just don't really understand the risks until actually it's a bit too late and they've already become symptomatic. So ensuring that regular workplace training is there to explain to people the risks of work-related upper limb disorders and what they can do themselves to mitigate against the risks of them developing any of these conditions.
Mark, there was such a lot of useful advice and examples of things that reps can do there. I think that was incredibly helpful. And what struck me is that so many of those examples should fall into the regular activities of a rep or of a health and safety rep. So even though risk assessments are not the responsibility of reps, you can, of course, have a role to play in seeing the risk assessments that your employer carries out. Remember, the responsibility is the employer's, it's not yours, but you have a role to can have an input into those. Of course, Mark also mentions if you notice more than one person or a group of people talking about the same issues, that may suggest a collective cause. If it's just one person, you might not spot a pattern, but when there's a group, there may well be something that is common to all these people that is causing their condition. And one great way you can find out if there is a collective something they've all got in common is by mapping the workplace, or body mapping as well. And as some of part of the TUC's resources that we have for safety reps are tools and information about how you conduct either a workplace map or a body map to find out what's happening to your members. It's interesting what you said, Mark, about posture. I know I am sat hunched here talking to you, and I'm looking around me in the office here, and there are people slouching, legs crossed. They're certainly not sitting straight. So it's certainly a common problem. Um, Before we move on to my next question, I wanted just to pick up on something you mentioned there as a resource. It's the HSE, is it art tool, art
Yes, the
assessment
art
tool.
assessment tool. Yeah.
We will send you out a link to this, everyone, along with a link to Mark's resource slides. But can you tell us a bit about what the HSE art assessment tool is, please?
Yeah, I mean, basically, if you look at the guidance that the HSE give, this is basically a tool that you can use to try and assess the risks really for different things. So you can look at the sort of task that you're looking to assess, and you can use the guidance to assess where that would fit within the HSE's sort of criteria, you might say. So, is it a moderate or strong force, for example? And by completing effectively the assessment, it will hopefully give you some guidance as to what the risk of that particular task might be. And you have to consider lots of different things when using that tool. So again, the force will be one thing. The frequency, of course, is another. And as I say, it sort of helps you sort of to identify whether it may be a sort of low, medium, high risk sort of task. Um, Again, there's a degree of sort of subjectivity around this. So again, whoever's completing the risk assessment, of course, has to be a competent person, because of course, whoever's completing that, if they get that wrong, frankly, it's going to give you potentially the wrong answer. And I've certainly seen that many times where we've had obviously an expert ergonomist involved in a claim where they've been assessing effectively the risk of the particular task. And quite frequently, you see the ergonomist criticising the risk assessment that's been done, because they say, well, they've just got this wrong. That is not, for example, a low risk task for these reasons. So it's sort of only as good as obviously the person assessing it at the other end, but it does provide some really useful guidance. And of course, there can be disagreements as to whether, a particular task falls in, one particular category or another. But it's useful to work that through, obviously, any particular task that you're trying to assess. The best guidance there is.
Thanks, Mark.
Okay.
Before the next question, I just want to highlight something that's just been posted in the chat panel. And one of our viewers says we should be mindful that health and safety, and maybe this issue in particular, isn't just for union members, and this is 100% right. And health and safety, we've often found, is one of the most effective ways of recruiting non-members via collective action. I think this is absolutely true. We've got lots of advice on how you use health and safety to organise and recruit members and get them on board with the union in the workplace. But yeah, if you've got when we remember what we said about mapping or body mapping a few minutes ago, you can absolutely include non-members in that. Why not? If everyone in the workplace is experiencing these conditions, they should of course be included and get involved in the union as well. Okay, Mark, you've talked quite a bit about the risk assessment side of this, which we know is the responsibility of the employer, and they have to have a competent person doing that risk assessment. But with regard to upper limb disorders or HAVs, what are the other employer responsibilities at any stage of the process, really?
Well, underlying lots of different regulations. So pretty much whichever one you want to look at. So whether it's one of the so-called six-pack regulations, the hand-arm vibration regulations, what sort of cuts through all the regulation, and whilst Of course, some do give guidance. So, for example, the vibration regulations have what's called an exposure action value and an exposure limit value, which basically is saying, you shouldn't clearly exceed the limit value. That's the absolute no-no, and that you should take certain steps when exceeding the exposure action value. For example, health monitoring would be one of them. But what sort of cuts through regulations really is that ultimate drive really to reduce the risk to the lowest practicable level. And again, there's some subjectivity in that what is the lowest practicable level, because of course it wouldn't be reasonable to expect an employer to spend, let's say literally millions of pounds to reduce exposure for one particular thing, when actually that reduction actually might work out to be quite modest, and actually not sort of that practical when you look at the sort of cost benefit analysis of it. So, the courts would certainly take that into account. What would it be reasonable to spend, say, £1 million changing the factory floor to reduce the risk by a relatively modest amount? But often is the case that actually much more modest things can be done at a much lower cost to reduce the risk. For example, education and training that I've mentioned earlier on. Usually that can be provided at a fraction of the cost, generally speaking, in-house by most employers to the workforce. That's not a expensive thing that they would have to do to minimize the risk. But the regulations really sort of, really boil down to that. Whilst you've got to do all these things and tick all these boxes, and they expect you to do risk assessments and the like, what of course that the employer still is under that duty to do. So even if, their assessment was, well, we think this is, for example, a medium risk of a work-related upper limb disorder, is that necessarily acceptable? Well, you could argue that clearly it's not. Well, a medium risk is still a medium risk. Some people are probably going to, fall foul of that and develop the condition. So, what more can the employer do, and can they demonstrate that they've looked at what they need to look at to improve the situation and minimise that risk, as I say, to the lowest practicable level? So that's the real driver, really.
Thanks, Mark. So by the time a case gets to you, it's obviously quite far down a process. It's not going to be the beginning. What sort of things can reps do that would be helpful to you if you're representing their member in one of these cases? And before you answer, is there a slide we should jump forward to on this, or is this something you're just going to
Not
talk
not
about?
really, no, no.
Okay, just so
I think, as I say, I sort of mentioned it earlier in the really the best thing that they can do is that sort of early intervention, really. So, medically, they may well need some attention. Is that seeing their own GP? I would say seeing occupational health will be preferable because they're having to bring that to the employer's attention. The quicker it's brought to the employer's attention, the better. The problem may well be remedied. If, of course, it's not, and sadly, we do see instances where people are ignored and, they're brushed away by the manager or whoever it is that they've spoken to. Again, if that's documented, and sometimes the difficulty, of course, is they say, oh, well, I spoke to such and such. Yeah, and that's okay. I mean, people will speak to people, of course. We don't always email each other and whatever. But again, it's quite helpful, I would say, where people do actually put it in writing as well. Particularly if something doesn't happen very quickly, why not follow that up? So I think to gather all that documentation in, if it was a conversation, where it's just been over and over again, the affected individual worker has been raising that with the employer, whoever it is in management or whoever, and that's being ignored. Did anyone witness those conversations? So it may well be, at least as a bare minimum, potentially gathering in the details of any witnesses to such things. And if, of course, if there is any documentation, so there's been any formal meetings, are there any minutes of that? Are there emails, etc.? If they've been to see occupational health and they've obviously got a diagnosis or anything's come of that, absolutely. All that will be very helpful to us as well.
That's great, Mark. Thank you. Now, we all know that employers have to have a workplace policy about health and safety. That's a given. That's a mandatory. But is there anything particular about work-related upper limb disorders or HAVs that can be included in a health and safety policy that would be preventative, or should they have their own policy even? And if so, what sort of things should be included there?
Yeah, I mean it's rare in my experience to see employers include anything within a policy. A sort of workplace policy like that. It sort of tends to be I would say much more general in what it will tend to cover, and then it tends to be the individual risk assessments for work-related upper limb disorder that will deal with what the employer is actually doing. So when they've assessed the risk and say, oh, and these are the things that we've got in place. So whether that would be job rotation, education, training, regular reviews by occupational health, those sorts of things. So that sort of tends to be in separate documentation, and it tends to be more a quite generic document that just sort of deals with their overall health and safety policy.
Thanks, Mark. That's really interesting to hear that you don't often see these things addressed specifically. But that, of course, we've got the other actions that you mentioned that are the responsibility of both the employer and then other actions that reps can take that are, they're not their legal requirement, but of course it can help members with these issues. Okay, I've noted down some things I wanted to come back to, and we've got some questions from the audience. But first of all, I've got a couple of general ones. Do you think that the stats we see from, for example, the HSE or other institutions accurately reflect the rate or number of HAVs, CTS, other rules?
Yeah, it's a real difficult one that in that I know the HSE said for the stats for 23-24 that there were about I think 543,000 estimated cases of a work-related upper limb disorder. Um, and in that, well, sorry, a work-related musculoskeletal disorder, should I say, which of course nearly half of that are back complaints. I suppose no surprise with that because it is the most common reason that people attend the GP. Back complaints are commonplace. Now it's a tricky one because there's only certain places that, of course, you can get the data from. So, if you're looking, for example, at a number of, the number of claims that were brought for work-related upper limb disorder, it's not easy to get a figure on that at all, because the statistics often sort of write back to the cases that were reported to the compensation recovery unit, and they're not always the best in actually categorizing the claim correctly. And of course, not every single case necessarily gets reported to the CRU. So my own personal feeling on that is that I am sure it's underreported. So whatever the figures are, I'm sure it's greater. What the true extent of that would be, I think it's an educated guess, and that's probably what the HSE is doing. It's an educated guess based on, of course, some of the data that they're able to get their hands on.
Yeah, I'd agree with you, Mark. I think there's so many cases that are unreported. I know of several, including myself, who don't talk about these things. Are certainly not on any official records. But yeah, it's probably whatever that around 500,000 figure that you mentioned.
Yeah.
That's probably just a percentage, right? A fraction of the total. Um, okay, another maybe quite general question. What is the success rate for these personal injury claims with conditions acquired from work related injury or basically all the conditions you've just been talking about?
Yeah, that's a tough one. I suppose it depends what you sort of where you're going at with the data, because we obviously see quite a lot of initial inquiries. A number of those, unfortunately, don't really get beyond the first base for one reason or another. Usually, some of the things we've been talking about around causation and breach of duty. Sometimes it's limitation as well, which I've sort of dealt with in the slides as well about the limitation period that applies to claims as well. Um, those that you might say get beyond that sort of initial screening process, actually our success rate, it doesn't sound great when we say 50%, but actually that very much accords with some data that was produced actually many years ago, when the Ministry of Justice were actually trying to figure out the success rate of various different claims. It was all to do with no win, no fee agreements or conditional fee agreements, and what were called success fees at the time, in the good old days when solicitors could recover a success fee from the losing party, rather than now it actually comes out of damages. And certainly for obviously, of course, claimants that are represented on a no win, no fee basis outside of the union. Obviously, the vast majority of unions, it's a free service as such. There's no deduction for any success fee or the like. But they looked at what they were calling at that point RSI claims, or repetitive strain injury claims, and they decided that the success fee would be 100%, so the maximum that it could be, because the cases were so problematic and so tricky, and the success rate was relatively low, actually below 50%. At that time. So they are tricky cases, don't get me wrong, for all the reasons we've discussed. But not impossible. Far from that. Far from impossible.
And like you said, 50%, for the reasons you just said, but 50% is still, it's good.
Yeah.
You mentioned briefly their limitation, and can you talk a little bit more about what you mean by that? And
Yeah.
a viewer has said, has it changed recently? They perhaps think it has. If you could address that as well, please.
Yeah, well, the sort of fact of the matter is, in our jurisdiction, England and Wales, obviously it can be different elsewhere. It's a bit of a different process, for example, in Scotland, and certainly for obviously people that work abroad outside of our jurisdiction. But talking about England and Wales, in essence, it's a 3 year limitation period. Now, of course, when someone suffers an accident, it's usually pretty easy to figure out when the 3 years starts, and of course, therefore, when it runs out. But of course, with this sort of condition, so whether we're talking about hand-arm vibration syndrome, which normally occurs, of course, over a period of years, the exposure that is to the vibration, or of course in a work-related upper limb disorder case, we're not talking about, usually, it's very rare in my experience, that someone on one particular day does a particular job and develops what they believe to be a work-related upper limb disorder in one single day. We're normally talking about a period of time, and it's normally weeks or months or even years. Um, and of course, when that person starts to develop the symptoms, quite typically, of course, they tend to be relatively modest to start with. So it might be a little twinge, they are little, griping. We've all had it where we might have done a bit too much one day, whatever we're doing, whether it's in the garden or whatever it is, and you go, oh, cool, my back's hurting, my shoulders hurting, my neck's hurting, whatever it is, and it passes. Over a relatively brief period, it's fine. You get back to normal. But of course, with these conditions, carrying on doing the same thing over and over and over again, of course, means that those symptoms continue. They generally get worse. And for those very unfortunate ones, it gets to a point of no return, you might say, where they've sort of gone over the threshold, where even when that exposure is stopped, um, that they do not necessarily recover. Now, most of the time, that's not the case, because they do cease the exposure, or it stops for whatever reason, or it's drastically reduced, and of course they do tend to recover over time, but that can take quite a significant period. So really, you've got to determine, well, When do those symptoms become significant? Now, that's a difficult one in itself because the very question to an individual is quite a subjective one. Well, what does, significant mean to you? And what does it mean to you? And what does it mean to you? It's different for different people. So the court have what's called the test of constructive knowledge. And this is where it can get a little bit technical because basically the judge will put him or herself in the shoes of that particular claimant and those circumstances, but then have to ask themselves the question, well, did they put two and two together? Did they effectively act reasonably in when they made that connection? And for some people, they will make that connection instantaneously. They'll go, I've always wondered, I've always worried that this job is going to cause me a problem. Now I've got these problems. I think this is what it is. And that suspicion is usually enough to trigger the start of the 3 year period. It's arguable, of course. If it's very mild, very modest, maybe transient symptoms to start with, is that significant? Is it caught by the significance test? My view on it is, if in doubt, go with the earliest possible date that you can. Don't fall foul with it. And it sort of goes back really to one of the earlier points about early intervention. I think as reps, the best thing that they can do is where they can clearly see that this is presenting a problem to that particular employee, then they need to be made aware, of their right to potentially pursue a claim and that this clock is ticking. Because it's no good someone getting to the point of, right, I'm 2 years and 11 months into the limitation period, and now I'll start a claim. Because if you've only got a month left on the clock, that's going to prove really difficult. So the earlier that anyone seeks attention, and whether that be medical attention, maybe first, I appreciate not everyone's going to want to go, okay, yeah, I'm going to go to a lawyer now, I'm going to get some advice about a claim. They may, of course, want to obviously, of course, get the medical attention first, maybe get a diagnosis, get some treatment, that sort of thing. But that's all very helpful, of course, as well. And of course, absolutely helpful to get them back, hopefully, on the road to recovery. But the 3 years, that clock is ticking. It's not always easy to determine when, but I would say take no risks. Really from the onset of the symptoms is what we work to as much as we can. It's not always possible, and sometimes, the explanation is it's very transient, didn't really trouble me until, and that might be weeks or months after they first started. But again, if they come early enough to us, that's far better. And of course, we've got more time on the clock, and we just don't want to run out of time.
Thanks, Mark. I mean, I think the thing to take away from there is that the earlier the better. But I do love how there's a discussion about everything, isn't there? Like when it started, when it didn't, whether you should have that. But that's the law, right? That's what the courts will do. It's not black and white.
No,
It's
no.
always up for discussion. You mentioned there a bit about medical diagnosis. So how essential is a physician report in all this and a physician's opinion?
It is really helpful to us because, of course, we're as medically qualified as probably any of you are. Whilst we've got obviously experience of dealing with the different conditions, of course, we're not really in a position to say, oh, this is X, Y, and Z. Whilst, of course, again, you might have a good inkling as to what it is that the individual's suffering from. Of course, it's really helpful if they've got a diagnosis. Not always, of course, is that going to be set in stone. And absolutely no disrespect to GPs when I say this, but they are general practitioners, and sometimes, they will come up with, the sort of umbrella term of, oh, you've got an RSI. Well, what is that then? You think it's a repetitive strain type condition, but it'd be quite useful to know what it is, because it gets more difficult to establish not only what it is that the person's suffering from and how it's caused, where it's what sometimes people call a diffuse RSI. So no one's really sure where it sort of starts and ends, you might say. They're just saying, oh, it's a sort of pain that I've got radiating in my forearm, for example. Well, does it start at the elbow or the wrist? Does it shoot up, down, or is it? And so sometimes you get sort of fairly innocuous sort of diagnosis, really. Of course, where people are referred on to a specialist, so they may go and see whoever it may be, a rheumatologist or someone like that. Of course, when they see an actual expert in the field, yes, that's probably a sort of more reliable diagnosis, you might say. And I say I'm not putting GPs down at all when I say that, far from it. But they are general practitioners. They're trying to be the master of everything, and of course, often the best thing for them to do, where it's appropriate, of course, is signpost. So they may have to refer someone, of course, to whichever medical specialty it may well be appropriate to.
Absolutely. And linked to that question, if someone has a diagnosis of carpal tunnel syndrome or any of the other conditions that you've mentioned, is there an obligation on someone to inform their employer of this?
Yeah, there certainly is. And certainly from a legal perspective, if someone was coming to us with a potential claim, and we said, "Well, did you inform your employer?" No. Why? That seems a strange thing. Why did you not tell them? And occasionally you get, an answer, for example, of, well, I didn't want to tell them because I thought it might jeopardize my job. They're going to get rid of me, that sort of thing. Sometimes there may be a really good explanation as to why they didn't say so. And if they were in fear of the job or they've seen other people complain and they're out the door, that's the sort of background to it. That's the sort of employer that they may be dealing with. You can sort of understand that. And of course, we may, again, have to explain this as part of the claim, because, of course, what you expect from the representatives of employers, their insurers, their solicitors, is to say, well, they brought this on themselves. They carried on working in these conditions, which they say caused the complaint, and said nothing about it. And without good explanation, they're either going to say, well, you're the sort of author of your own misfortune, which is really strong because that's nonsense, really. Uh, Before they're symptomatic, the employer, of course, you would argue, should be doing all the things that we've discussed already. Um, okay, yeah, if they're then symptomatic and they carry on doing the job, they say nothing, the condition gets worse. Yes, you can understand the other side trying to argue, well, from that point onwards, there may be at the very least contributory negligence on part of the employee because they've remained silent, they've not brought it to the employer's attention. So I would say for the vast majority, of course, yes, absolutely bring it to the employer's attention. They should be looking at it, they should be looking at this job again, risk assessing it, looking at that individual, absolutely look at occupational health referrals, all that type of thing. I do understand that there will be some people that work in places where they feel that they cannot speak out, but it has to be explained in those circumstances as to what the background is to that.
Thanks, Mark. I've got a couple of bit more technically detailed questions for you now, but they're not super technical. Um, in your experience, can low indoor temperatures or any adverse indoor temperatures increase the risk of developing these conditions, or do they just aggravate ones that you've already got?
No, it does. It does increase it. Absolutely for certain for hand-arm vibration syndrome. There's well documented research that does confirm that if someone is working in lower conditions, hence why the HSE, for example, will say wear gloves. And sometimes there's the misconception, oh, there are these things as uh, these anti-vibration gloves, which are absolute nonsense. Whoever sells those are talking absolute nonsense. There is no such thing as anti-vibration gloves. Gloves will, of course, keep the hands warm, or at least better than having none at all. So, absolutely, if you can keep the hands warm, absolutely that will assist. Now, again, it doesn't sort of stop the effects of the vibration, but we know that where people are exposed to vibration and they have cold hands, and well, they are just generally cold, the whole body's cold, and it's sort of sucking the heat into the sort of core really to protect the organs. We know that the effects of vibration are amplified as a result of that. And the same really can exist as well for work-related upper limb disorders, because again, if you think about it, if someone's really quite cold and they've not got the blood flow and whatnot, then clearly, whether it be your hands, your arms, your shoulders, whatever, it's just not, they're just not going to work as well and effectively as it should. Um, so any sort of blood flow restriction like that because of low temperature, yeah, potentially is a concern.
Thanks, Mark. Um, have you got any legal advice or guidance for reps who are dealing with members who work from home part of the time? Um, I'm assuming that they're going to be desk based when working from home, but obviously they are still contracted to the employer. What are some of the considerations for those people?
Yeah, well, I mean, I would say first of all, and again on the HSE website, there's advice about home working and desk assessments and how people can sort of do that for themselves and how to set up correctly. So people can certainly help themselves. I appreciate the practicalities of the employer doing an assessment, particularly if someone works at home and they're not always in one particular place. And I can imagine that this happened certainly through the whole COVID situation, where people were very makeshift. They weren't necessarily set up for working at home. People were sat at the kitchen table, or they got the laptop on the knee, and all sorts of I'm sure pretty incorrect ergonomics were going on. So they can, individuals can help themselves by trying to do their own assessment. Again, there's a HSE guidance on their website about home working and how to do that. Um, but certainly, the employer still has the duty of care. There's absolutely no doubt in that at all. So if anyone has concerns that their working environment, whether that be, at work or at home, isn't suitable, they need to be bringing that to the employer's attention straight away, asking for an assessment, or indeed if they think they're lacking certain equipment. So they may say, oh, well, I need a stand, or I haven't got the correct seating, whatever it may be, a footrest, I need an ergonomic mouse, whatever it may well be that they think the issue is, bring it up to the attention straight away.
Yeah, thanks, Mark. I think the key thing you said there was echoed by one of the viewers in the chat, that whether you're working from home or from the employer's premises, they still have a legal duty of care to you.
Yeah.
You're in their employment. It doesn't matter where you are. So yeah, absolutely. As Mark says, bring these issues to your employer's attention if you feel there is something lacking, if you feel there is something needed, or if you want to have an assessment done. You you know Lots of employers have contracts with external assessors who can come and look at this for you if you're working from home, much as they would come to the office or to another premises. Right, we've had so much really key information from you, Mark, about both the legal process and, crucially, the workplace process as well, i.e., the bits that happen before they come to you,
Mhm.
in order to help people who may have these conditions, and how then it helps you represent them, but also some of the preventative things that employers can do, and things that reps can hold employers accountable to do to try and stop these happening in the first place. This webinar today was, of course, one in a series we've been doing with um, solicitors from Thompsons. We will make sure that we had one originally about workplace illnesses and injuries and the legal process in general. And then we've had this session with Mark. We've had one about respiratory illnesses, and we're going to have another one in a couple of months' time about some of the other conditions that you can claim for as well. So thank you so much, Mark, for joining us today. You've been fantastic. Thank you all for joining us. This is our last webinar before we break for the summer. We've done a lot these past couple of months. We hope you've all enjoyed them, and I hope you've all found them as insightful and as helpful as I have. We'll see you all again soon for more webinars from Thompsons and from us and other expert speakers. So bye-bye for now, and we'll see you in September.